World Arbitration Update. And what I meant to say is that I'm here in Washington, but all of our panelists are from various corners of the world. I know Chester Brown, who's our moderator, is in Australia, and others are in Europe and in North America. So we're going to have a very interesting panel on one of the topics that we've been looking at over the past 5 days of the World Arbitration Update, and that concerns issues related to investment arbitration. We've also had topics on commercial arbitration, and yesterday on the WTO. Really, this panel is a great example of what we've been trying to do at WOW to address diverse topics, to address topics that are becoming very topical and ones that people are looking for updates, hence the topic of the conference. And it really reflects the diverse nature of international arbitration itself. Over the last 20, 30 years, international arbitration has really moved from the centers of arbitration in the typical locations to all over the world. And we see practitioners and arbitrators and our users from every corner of the planet. And we when I say we, I mean Dr. Jose Antonio Rivas and myself and the team at X Strategy. We really wanted to create a conference that reflected the highly diverse and widespread nature of international arbitration today. And we hope you'll enjoy this session. There's a couple more sessions this morning and this afternoon. We recommend those to you. But let me first, before we kick off, introduce Professor Chester Brown. He's our moderator this morning. He's a professor of international law and international arbitration at the University of Sydney Law School. And he's also the law school's director of global engagement. He's a barrister as well. He's at the 7 Wentworth Selborne Chambers in Sydney, and he's also an overseas member of Essex Court Chambers in London. His fields of focus are international law, dispute settlement, arbitration, investment law, of course, and private international law. So he's really well suited to today's topic. He's also been a practitioner and been before numerous courts, including the ICJ, the Iran-US Claims Tribunal, as well as investor state tribunals. So we're really looking forward to getting Professor Brown's perspective on this issue. And I'll now pass over the microphone to Chester. Chester, looking forward to the panel.
Great. Thank you very much for that kind introduction, Ian. It's wonderful to be with you all here for this iteration of World Arbitration Update. The first time that World Arbitration Update has been held, but this is one of several panels, obviously, that's been held this week. Good morning to you all, with having an early start in the United States, and good afternoon to you in Europe, and good evening to those of you who may be joining from a similar part of the world as me. Now, we've got an excellent panel this evening, but I'll just give a short introduction to the topic, just a very brief introduction to the topic. And it's just to note that in 2011, the United Nations Guiding Principles on Business and Human Rights were adopted by the United Nations Human Rights Council. These guiding principles had been developed by the United Nations Secretary General's Special Representative on Business and Human Rights, who was Professor John Ruggie, who was Professor of Human Rights and International Affairs at Harvard University's Kennedy School of Government. And the guiding principles really could be distilled into a short catchphrase of 3 words, and they are protect, respect, and remedy. And the United Nations guiding principles have become a very important framework for countries to implement in their domestic legislation, and also for corporations to take into account in implementing their corporate social responsibility policies. And that is no more important, of course, than when they are engaged in operations overseas. Now, sadly for us, Professor Ruggie passed away just a number of weeks ago in September 2021, but he's left a very important lasting legacy. And we did hope to have with us on the panel this evening one of his research assistants who worked with him throughout that process of developing the UN guiding principles on business and human rights, Andrea Schemberg, whose name you may have seen in the program, but sadly due to a family bereavement, she can't be with us today. But we do have an excellent panel, and I'm going to introduce our panelists to us now. We're going to begin with Dr. Klara Polachkova van der Ploeg, who's an assistant professor at the University of Nottingham in the United Kingdom. She specialises in international investment law and international dispute settlement. Her research involves transformations of international law with respect to collective non-state entities, the international legal regulation of global coordination problems, and international law in domestic courts. She completed her PhD at the Graduate Institute of International and Development Studies in Geneva in Switzerland, and also holds an LLM from the University of Michigan and master's and bachelor's degrees from Masaryk University in the Czech Republic. And she's also been a visiting fellow at the Lauterbach Centre for International Law in Cambridge, at the British Institute for International and Comparative Law, and also Queen Mary. And she also served as a judicial assistant at the International Court of Justice to Judge Sir Christopher Greenwood. Our second speaker is Jose Antonio Rivas, who is, of course, one of the organisers of World Arbitration Update this week, and he is a founding partner of X Strategy LLP, a boutique law firm for international arbitration based in Washington, DC and Bogota in Colombia. He has 18 years of experience in international investment law. He has had a number of different roles. He's worked as counsel for sovereign clients and investors in arbitration proceedings. He sat and is sitting as arbitrator in domestic and international arbitrations. And he's a former lead negotiator for the government of Colombia of its international investment treaties over a number of years. And on top of all that, he's also worked as ICSID as one of the legal counsel in that institution. He also serves as an adjunct professor at Georgetown University in Washington, DC, and he's a member of the ICSID panel of arbitrators and conciliators. Last but not least, we have Rob Houston joining us from Singapore. He is a senior associate at K&L Gates Straits Law in Singapore, who works in the international arbitration team there. He has acted for and against states and state-owned entities, major corporates and other clients in complex cross-border matters with high-value disputes, including in investment treaty and commercial arbitrations under various institutional rules. And Robert is also the pro bono coordinator of the Singapore office of K&L Gates, and he's a founding member and executive director of the Global Pro Bono Bar Association and a leader in the firm-wide anti-human trafficking initiative, in which he has coordinated a number of multi-jurisdictional pro bono projects involving multiple K&L Gates offices and other collaborating firms around the world. Robert holds a Juris Doctor degree from Georgetown in Washington, DC, and a Master of Economics degree from Sciences Po in Paris. So much for our introductions. I'm sure you'll agree we have an excellent panel, and I'll ask Klara to take the floor and ask her to give her presentation. Thank you.
Thank you very much. And thank you for the invitation to join the World Arbitration Update and this particular panel. I have some slides, and I believe Maria will kindly help me with them. I have been invited to, I suppose, set out the state of play in relation to the question of incorporating obligations of investors in BITs. And I am compelled to say that Professor Brown's introduction, which focused on the UN guiding principles on business and human rights, sort of sounded as if investment treaties at the moment have very little to say about the conduct of investors and possible investors' obligations, and this is why we need the UN guiding principles. Now, I suppose the main disadvantage, so to speak, of or maybe advantage of the UN guiding principles is that they have left the question of the legal nature of the requirements on businesses open. So it is not quite clear whether they stipulate simply some normative expectation of there is something more. Anyway, I would like to talk about investment treaties in my 15 minutes. Investment treaties have been known and more recently also criticized for their normative asymmetry. So for the fact that they in principle impose only obligations on host states while conferring only rights or benefits on investors. And investment treaties have indeed focused on the conduct of the host state and the impact of the host state's conduct on the protective investment, leaving the conduct of investors generally out of the picture, except possibly for the limited aspect when the definition of investment, the definition of protected investment, would set out a requirement for the investment to comply either in its establishment or possibly also in the operation with the domestic law of the host state. However, as the experience with the application of investment treaties in investor-state arbitration grew, and it became apparent that most tribunals adopt an essentially strict textualist approach in the interpretation of these treaties, and will therefore not be prepared to take regard of investor conduct in the absence of any specific treaty language. For many, I suppose, the normative asymmetry of investment treaties and their lack of attention to investor conduct has been one of the elements putting the legitimacy of the whole investment treaty framework into question, especially given the often demonstrably detrimental impact of foreign corporations in the host state on its population or the environment, the absurd leverage investors often have over host governments, and the limited ability of some states to effectively regulate investor conduct in their territory. Now, with the availability of ISDS, this normative asymmetry and its effects became even more apparent. This idea that investment treaties should incorporate also provisions dealing with investor conduct has become part of the ongoing processes of reform of international investment law, such as spearheaded by UNCTAD. And we have seen provisions dealing with investor conduct to emerge in newly concluded investment treaties. Now, what is it that we can see? If I can ask for my next slide. So these provisions dealing with investor conduct would at times take shape of sort of a very familiar normative solution. They may simply ask each party to encourage enterprises to do something, such as voluntarily incorporate internationally recognized standards of corporate social responsibility. And I have given you the example of the Canada-Serbia BIT. In some treaties, the formulations we would see would actually directly address the foreign investor or the local corporate vehicle, in the language of these provisions, the investment. And they would say, such as the 2015 Slovakia-Iran BIT, that investors and investments should apply national and internationally accepted standards of corporate governance. Or in other treaties, such as Argentina-Qatar BIT, they may say that investors should make efforts to voluntarily incorporate recognized standards. Or we could also see provisions such as in CETA, in the Comprehensive Economic Trade Agreement between the EU and Canada, which would prevent the investor to bring a claim in investor-state arbitration if the investment was made through fraudulent misrepresentation, corruption, etc. However, the practice has gone beyond the evidently soft law clauses or this procedural rule of preventing access to something more, I would argue. And contrary to general perception that as a matter of positive law, there are no formal investor obligations under investment treaties, some treaties, in particular some of the recent treaties, and including treaties in force, contain provisions which prescribe, at least on their face, obligations for foreign investors or the local corporate vehicle, the investment. So if I could ask for my next slide to just give you a general impression. I can imagine that many of you cannot read really what is on this slide. And my intention here was just to convey the message that there are multiple instruments with such provisions. And even this slide is by no means exhaustive. So let's zoom in onto a couple of the clauses on the next slide to have a closer look what these provisions say. So I've chosen just two examples here. Ethiopia, Qatar, investors and investments shall comply with the labor and investment laws, etc. Or the Morocco, Nigeria, investors and their investments shall not offer, promise, or give any undue pecuniary or other advantage, etc. and anti-corruption provision. In fact, many contemporary model bilateral investment treaties articulate these kinds of provisions as well. If we look at the model BITs, which were adopted since 2015, among the publicly available ones, more than half contains this kind of provisions, including the Netherlands model BIT, Belgium, Luxembourg Economic Union, Nigeria model BIT, or India model BIT, etc. So the question naturally arises, what are these provisions? Can and do they actually create formal obligations for investors? Now, some commentators dislike the proposition that investment treaties should create international legal obligations for investors, viewing such development perhaps as an unwelcome expansion of personal scope of international law, something that is at odds with the main doctrines of international law, such as the doctrine of sources or the law on international responsibility. Others may focus more on the fact that treaties are interstate instruments and investors are not parties to these treaties, and therefore they cannot and do not consent to any such purported obligations. Let me take these concerns in turn just to set out the main features of the debate. I suppose the objections, which are essentially objections to the possibility, the legal possibility that investment treaties set out or impose obligations of investors. The first two dealing with the doctrine of subjects and law of international responsibility, they will go along the lines of only states being the proper subjects of international law, and therefore they should be the only ones who can be addressees of an obligation in under international treaties. Now, this seems less of a compelling point in the sense that the whole doctrine of subjects of international law has kind of arguably lost its capacity to describe what is going on in international law. There are now multiple formulations of what the doctrine says or doesn't say. Notions such as those of partial subjects of international law have been introduced, etc. In fact, the one common thing to all these approaches is that they look at whether or not the entity in question is an addressee of rights or obligation under international law. So it's sort of a circular problem. We could say then that it's easily dispelled by simply pointing out, well, if we have the problem, if there are rules of international law which address these entities, well, that could make them subject in some way, if you insist on using that doctrine at all. The same with the law of international responsibility. The ILC articles make it quite clear that they are in no way exhaustive statement of all law on international responsibility, and it actually seems a wide accepted principle that a violation of an international legal rule will engage international responsibility regardless of who the addressee of the obligation is. Presumably, the more interesting objection is the one based on the lack of consent. And here I would ask for my next slide, please. Which from the perspective of which from the perspective of treaty law would be the pacta tertius rule, that treaties cannot bind their non-parties. And typically what we hear is reference to the Vienna Convention and on the law of treaties and the and Articles 34, 35, which express this principle. But as you can see, these provisions explicitly speak about third states. So strictly speaking, they are not applicable to the situation before us. And therefore, they do not really resolve the pacta tertius problem of whether investment treaties can or cannot bind investors. Let's have a look again at one of the examples of these provisions and consider then what these treaties seek to do. Can we have the next slide, please? So this is an excerpt from the 2008 ECOWAS Supplementary Act on Investment, which is a treaty in force among the member states of ECOWAS. And this treaty actually contains a whole chapter entitled Obligations and Duties of Investors and Investments, which set out really wide-ranging requirements on the on these entities, such as to conduct environmental and social impact assessment when making the investment, to apply precautionary principle when dealing with the results of these assessments. I have underlined some of these requirements just to bring the specific sections to your attention. But there is an anti-corruption provision, so saying that investors and investments shall not engage in corruption, but also provisions such as in Article 14.2 that investors shall uphold human rights, or that in paragraph 4, that they shall act in accordance with fundamental labor standards as stipulated in the ILO Declaration on Fundamental Principles and Rights of Work. Now, you can see that these provisions are formulated in a language of legal obligation. So stating that an investor or an investment, the local corporate vehicle shall or shall not engage in particular conduct. And anyone who has ever observed international negotiations will know that states are quite aware that the language shall is one that designates creation of legal obligation. And so they will be careful not to use it in case they do not intend normative effect occur. So I suppose it would seem that this mandatory investor addressed shall language expresses the state party's intention to impose legal obligations on foreign investors. The language is clearly distinct from provisions that address investors but use the hortatory expression should, etc. And the intention to create legal obligations for investors has also been confirmed through statements of representatives of states on occasion in various international fora. So I suppose my point here is that international law has been built on or is built on I suppose a number of principles, but the one that really seems to be foundational is this idea that state practice is normative. So that it would be, in fact, within the competence of states to use treaties as effectively a lawmaking instrument. So the same way as they will domestically legislate for private parties, they could use treaties as a lawmaking instrument at the international level. And indeed, if we look across the landscape of international law, this would not be the only instance when treaties have been used to impose obligations on non-state entities. So we see that both in relation to individuals and in relation to collective entities, for example, in the law of the sea or in humanitarian law treaties. So I suppose let's move to my next slide. I thought I should give just a an overview, what are the types of obligations, the type of content that we may see in these treaties. And they will include obligations to comply with the host state's law, reporting obligations, anti-corruption obligations, but also investor liability for harm, which is interesting. And I expect that one of the other panelists will talk about this problem. Obviously, a provision or an obligation under investment treaty may, in certain circumstances, serve as a basis for a claim by the host state against the investor, but it will not serve as a vehicle on its own for victims of any injury by the foreign investor. And so some of these treaties, in fact, contain a provision which set out the possibility for such claim by private parties. Perhaps the last thing I would like to tell you about, if I may ask for the next slide, would be, because we as practicing lawyers will always say, okay, well, what do the cases say? And there is arguably there is very little, and as far as I'm aware of. And in fact, there is only one case that I'm aware of that has dealt with a provision of the sort of an investor shall, in this case, be bound by the laws and regulations in force, and shall refrain from all acts that may disturb public order or morals, or that may be prejudicial to the public interest, which is Article 9 from the Organization of Islamic Conference Investment Agreement. And in Alvarak, Indonesia case, the arbitral tribunal took the view that this is really a direct obligation on the investor. In fact, the investor themselves agreed that this was an obligation that the treaty imposed on them. And what the tribunal found that the claimant, the investor, actually breached this obligation, and by virtue of that breach was prevented from pursuing a claim for a violation of the standards of protection of their investment. So even though the tribunal took the view that the claimant did not receive fair and equitable treatment, they could not claim and they could not request compensation. In that case, the host state actually tried to go a bit further and also filed a counterclaim, essentially seeking damages for the breach of the article of the obligation, and there it didn't succeed. So the award is quite brief on this point. It seems that they simply did not really carry the evidentiary burden and explain what specific injury was attributable, or what specific damage was attributable to the investor in the arbitration. So I suppose my conclusion would be that one of the questions is if it is possible for BITs to impose obligations of investors. And I gave you some ideas as to whether or not this may be the case. But even if it is, the question is it a good idea to do so? And if it is a good idea, then what should be the content of these obligations and what would be their effects? And with that, I will stop because I expect that this is what my colleagues will be talking about. Thank you very much.
Great, thank you very much, Clara, for that excellent introduction and overview of the state of play with respect to treaty practice and attempts to incorporate obligations on investors into bilateral investment treaties. I'll hand the floor over now to Jose Antonio, who is going to take the conversation forward. Thank you, Jose Antonio.
Thank you, Chester, and thank you, Clara, for your wonderful presentation. It actually helps me quite a bit because you covered some of the things that I was afraid I would not be covering. So it knits very, very well into what I will be sharing with everyone. So let me share my slides. Can you all see it? Or not yet? Yes, excellent. Okay, so I will address the investment treaty architecture incorporating investor obligations, and what this means is how to create a treaty that would be practical and that would ultimately, if relied upon by a state for certain breaches of the investor, would pass the several tests, jurisdictional tests, as well as merits tests that an investor state tribunal would actually do when analyzing a case of a breach of certain investor obligations in an investor state arbitration. There are a couple of questions that are obvious here, and I would like to briefly address some of them. One is, why investor obligations in investment treaties? Is it balanced? Nowadays, there's a whole discussion in UNCITRAL about reform, and it has been said, as indicated by Clara, that these treaties are asymmetric because they mainly include obligations of states, but not obligations of investors. So one reason would be balanced, and if anything, in my mind, even beyond the court, or beyond a number, I'm referring to the investment multilateral court that is being proposed in UNCITRAL Group 3, and beyond a number of reforms that are being proposed. One question in my mind is what could bring balance to the system in a system that has 3,300 treaties, and most of them, I would claim that less than 1% of those treaties have investors' obligations. There's something of a innate asymmetry and imbalance in a system such as the one that we have. So seriously looking at bringing some balance to the table, the issue of investor obligations should be addressed. So that's simply to say, in what camp am I when we think about investor obligations? Then the next question is if you include certain investor obligations in an investment treaty arbitration or an investment treaty, how do you still respect the principle of consent? As Clara well said, well, the treaty is really an instrument that is agreed upon by two subjects of public international law, the states, and the investor is not party to that treaty. So one would say, if one is respectful of the principle of consent, that the treaty is unable to impose obligations on the investor, except if the investor consents. So that's the big if. And then comes the question of practicality. How do you create an architecture that would include that consent, and that, when analyzed by a tribunal, would be affirmatively upheld in terms of jurisdiction and in terms of merit? So those are the questions. Now, based on those questions, what we have here is a roadmap of two parts. One, the obligations of investors, which may give rise to direct state claims or counterclaims. And the second part is the architecture itself, which is the main subject of my presentation. I'm really thankful to Clara, because the first part was incredibly well addressed. So that gives me a little bit more time. But before going there, I would like to emphasize two problems that that arise in that question of how to create a treaty that would pass the test of a tribunal. And let's see on the jurisdictional front a recent case, the Naturgy Electricaribe versus Colombia case. In that case, the Republic of Colombia submitted a counterclaim, and the case relates to energy in the coast of the Caribbean coast of Colombia, and Colombia argued that Naturgy's mismanagement of Electricaribe forced it to channel funds into the company to maintain its operations during the intervention, and produced a negative impact in regional development in the whole coast of Colombia. The tribunal basically assessed under the test provided by Article 46 of the ICSID Convention. It assessed whether there was a consent to bringing a counterclaim, and it concluded that under the applicable article of the BIT between Spain and Colombia, the scope of consent was too narrow as to include counterclaims. It also analyzed the counterclaim, and it concluded that the case on counterclaims was not sufficiently linked to the original claim. So those are two elements of Article 46 of the ICSID Convention, and you can see here that there was no consent by the investor to bring a counterclaim. So part of this is the scope of the scope within the treaty, the applicable treaty, to allow for the counterclaim or the direct claim by the state to be brought. So it has to be sufficiently broad as to include counterclaims, either because they're specifically spelled out in the treaty, or because the treaty says that any disputes can be brought by either party. For instance, that kind of language would allow a counterclaim to be brought. So beyond that, we've looked at a more jurisdictional question. Beyond that, let's say that the scope of the provision on investor-state arbitration within the applicable treaty has a sufficiently broad language that would include counterclaims. That's only one part of the problem. The other part of the problem, and just to see within this slide, you have a number of decisions that have, most of them have been dismissed on jurisdictional grounds. The ones that have made it on both jurisdictional and merits grounds are counterclaims that have been based on a contract claim, not on a treaty claim. The only one that has made it based solely on a treaty claim has made it past jurisdiction. At the end of the day, they didn't make it on the merits, but they made it past jurisdiction, is Urbacer versus Argentina. There's a couple of cases against Ecuador where there were both contract claims and treaty claims, but those ones were also based on contracts, not only on treaty claims. But the one that has made it solely on the basis of a treaty past jurisdiction is Urbacer. So let's look at Urbacer. In Urbacer, we have Argentina brought a counterclaim arguing that Urbacer's failure to provide the necessary investment caused a violation of fundamental right for access to water, which was the very purpose of the investment agreed. Then the tribunal declared that it had jurisdiction over the counterclaim, considering that the principal claim and the claim opposed to it are based on the same investment or the alleged lack of sufficient investment in relation to the same concession. So far, so good. But then when it analyzed the actual substantive claim, the tribunal concluded or dismissed the case on the merits because none of the provisions of the BIT had the effect of transferring the concession to the concessionaire an obligation to perform services complying with the residents' human right to access to water and sewage. So this is a tricky bit of most BITs. So with that, it is extremely important that if a treaty is to be is to make it past jurisdiction, there be some obligations of investors that they have to comply with. And Clara already provided a very precise number of treaties that have shall, the shall do or shall language. I'm just going to give you one punctual example, which I believe is a very strong language, the Morocco-Nigeria BIT. In paragraphs 2 to 4, it's quite evident that this would be international obligations and not only domestic obligations incorporated by reference. This would be international obligations that the state, the investor has to comply with. So for instance, paragraph 2, investors and investments shall uphold human rights in the host state. Or 3, investors and investments shall act in accordance with core labor standards as required by the ILO declaration. Or investors and investments shall not manage or operate the investments in a manner that circumvents international environmental, labor, and human rights obligations. So as to the content, you can actually look at the content basically by referring to a number of ILO conventions, which I will not deal into that because of time, but the presentation will be made available. Other parts of other contents that would be of importance, I believe, the precautionary principle in environmental international law. So once you have the obligations, where do you go? We still don't have consent, and this is where the architecture becomes important. This slide shows a very similar language to the Nigeria Morocco BIT, so I won't go into it. And this is the slide that really makes a proposal concerning the architecture. And the proposal, I'll explain it, is very straightforward, which is you could, as a state, you could gather the investor's consent by making an explicit confirmation by the investor that he will comply with the investor's obligations before the request for arbitration is submitted, or at the time that the request of arbitration is submitted. So I'd like to sort of explain how this would work. In NAFTA treaties or in DR-CAFTA treaties or US-Colombia treaties, there are requirements of consent. If the investor does not comply with those requirements, then consent to arbitration by the state is not given. So what a state may create is an annex which would include a specific condition that the investor would have to fulfill for the tribunal to understand that there has been consent by the state for the submission of the request for arbitration. If that annex is not signed as a confirmation by the investor, then that dispute would not be within the scope of the tribunal. Just like a number of waivers are required in NAFTA-like treaties. So, and I'll try to repeat it because there would be an annex, and within that annex, there would be a requirement that the investor acknowledges that those obligations exist, but also that those obligations bind the investor. And the content of that annex or proposed annex is provided here. So it reads, you know, or the reference to that annex is provided here. So it would be included within the articles on conditions precedent to submission of a claim to conciliation or arbitration. And paragraph 1 would read, a disputing investor may submit a claim to conciliation or arbitration only if the disputing investor submits the completed form of consent to counterclaim of arbitration and thereby confirms its consent to be bound by those obligations included under Article X, wherever the behavior of investors is in the treaty, and consents to international arbitration in the event that the disputing party submits a counterclaim arising directly out of the subject matter of the dispute in the same arbitration forum and before the same arbitration tribunal hearing the dispute submitted by the disputing investor. That, in my view, would solve the issue of consent, because unless the investor signs the form, there would be no jurisdiction for the tribunal to hear any part of the case, neither the investor's claim nor the state's claim. And with that, I would like to conclude my remarks. Thank you very much.
Thanks very much, Jose Antonio. Some very interesting treaty practice there. Without any further ado, I'll pass over to Rob. Thank you, Rob.
There we are. Okay, so let me ask to confirm, could you see the slides as I put them here? There we are. Are we able to see the slides? Great.
Yes.
Okay. Thanks very much, Chester. So I'm delighted to be here and to speak with you about such an exciting, such an interesting topic, incorporating obligations of investors in bilateral investment treaties. Great presentations have come before me, and I'm delighted to hear the comments that have been made because they remind me of some of the recent practice that we've been engaged in, and I'm happy to talk about that. So first, I'm based here in Singapore. I've acted for sovereign states in a number of contexts. I've also acted in investment treaty and commercial disputes, and I have experience with a range of arbitral rules. I'm here first to say thank you to the WOW conference organizers and to my fellow panelists. What I'm here to say is not offered as legal advice, however, and I want to make sure that I mention that I'm appearing in my personal capacity and that my opinions or views expressed here are mine alone and do not necessarily reflect the opinions or views of my law firm or of any other entity or individual. So,
Rob, before you go on, I've just noticed that as you got off the first or second slide, the slides are not quite aligned as I'm seeing them. I don't know if others are having the same problem. I think somebody else was in the chat. But is there any way that they can be
That's a good question. Let me ask, Maria Lucia, are you able to, maybe if you share them, maybe that'll fix the problem? I guess the format may be off. Can we have a quick look? Oh, there we are.
I think that's better already. Yeah.
Yes, indeed. Thanks very much.
Yeah.
Okay, then we'll just say next slide. Thanks very much. Next slide. Okay, great. So we've said this. Next slide. Okay, great. So we'll talk about four things. First, we'll talk about confluence in just a moment of a couple of regimes in public international law. Then we'll move on to treaty modeling, essentially moving those two regimes in public international law together. And then the Hague Rules, we'll speak about that briefly, and then we'll finally conclude with future practice. Next slide, please. So confluence, we'll have it, just the next slide, please. So we're talking here today about the confluence of two regimes of public international law. This has already been discussed by the panelists today. On the one hand, we have investment protection. On the other hand, we have business and human rights. And many people have seen in the center the opportunity, the potential of bringing those two regimes together into the next generation investment treaty models. Next slide, please. We're here to talk about how to do that. Now, the entire conference is about the investment protection and promotion side of things. So we'll talk just a bit about the business and human rights regime. It's already been mentioned, the UN Guiding Principles on Business and Human Rights, 3 pillars to it: the state duty to protect human rights, the corporate responsibility to respect human rights, and then finally the access to remedy. I would just point out that pillars 1 and 3, those are applying to states. Pillars 2 and 3 apply to corporates. So pillar 3 is the one that is shared. Next slide, please. So we have an objective stated in the UN Guiding Principles. This is in the general principles section. It says, enhancing standards and practices with regard to business and human rights so as to achieve tangible results for affected individuals and communities, real live folks, real people, and thereby also contributing to a socially sustainable globalization. Interesting to me here is the fact that we're talking about an end game of globalization, and it's also the case that a lot of people might say, anyway, that the investment protection regime has the benefit of increasing globalization in some respects, or at least cross-border investment in some ways. Interesting to see that there is some overlap even in terms of the objectives. The UN Guiding Principles are organized into foundational principles and operational principles. I mention that because the foundational principles are a little more broad, a little more general. Operational principles, they start to be a little more specific. Next slide. So what does it mean to, as a corporate, as a private sector entity, that business and human rights obligations should apply to you? Well, Guiding Principle 11 says that business enterprises should respect human rights. This means that they should avoid infringing on the human rights of others, and also they should address adverse human rights impacts with which they are involved. Now that's, once again, general language, and some people might say, well, what does that mean? It's so general. Let's take a look then at the next slide. Guiding Principle 15, still in the foundational type of principle, but drilling down just a little bit here, we have something that becomes a little more specific. We have a policy commitment. We have a human rights due diligence process that must be in place. We also have processes to enable the remediation. And this Guiding Principle 15 is followed by even more specific principles as well. And so it's not just that this is aspirational language. It's not just that the guiding principles are there to provide kind of general guidance, but nothing specific. There are specific obligations on corporate entities that are listed and understood under the UN Guiding Principles. Next slide, please. So how do you take those UN Guiding Principles and put them to work into investment treaties? That's the question that's been discussed here, especially with respect to the topic of consent. And that's what I'm delighted to talk about today, because that's some of the work that we've been doing recently is on this very topic. Next slide, please. So recently, we have seen the same picture: investment protection on the one hand, business and human rights on the other, in the center, potential. What we've seen there in particular, however, is a new treaty model that we have developed that we think is a next generation treaty model called the Sustainable Investment Facilitation and Cooperation Agreement, or SIFCA, the SIFCA. Next slide, please. Now, the SIFCA came from a client need, like most things that come in the private practice of law. There was a need by a least developed country for the development of a model bilateral investment treaty, a BIT. And so that's how we developed this, was for the specific concerns of a particular least developed country. That's the perspective, the kind of conception that we brought to this discussion. Now, It starts with the baseline limitation of the scope of state obligations. That's kind of the baseline expectation within the CIFCA. And I won't talk about that today so much because many people do talk about limiting state obligations. The idea being that you don't want to make the promise, to investors upfront of a certain broad scope, like, for example, some of the bits that have been written and put into place back in the 90s. Very broad scope of substantive obligations. You may not want that these days as treaty practice evolves. But we've gone a little farther than that. Next slide. In the CIFCA framework, we are looking not just to limit the scope of the substantive obligations that states take on, but also to introduce investors' business and human rights obligations as a shield for host states. So that's one thing, right? The conversation so far, we've been talking about how to kind of apply business and human rights obligations to investors for their own sake, and that's definitely a valuable conversation. But here, just to start out, using business and human rights obligations as a shield for host states in international investment agreements. Secondly, to reduce power imbalances in investor-state dispute settlement between developing states and well-funded investors, and also to promote more equal sharing of risks and benefits in modern investment treaty practice. Next slide, please. So, pre-arbitral requirements under the CIFCA. This will look very familiar to many practitioners. The exhaustion of local remedies, it's a common thing. The notice of potential disputes, some sort of notice requirement, a 6-month period for consultation and negotiation. These things are all in a number of treaties and they exist in the CIFCA framework as well. Moving on beyond that step though, beyond that level of evolution, let's say, we also require a further advanced notice with an investor declaration of compliance, both with the terms of the CIFCA model itself, the instant treaty, and the UN guiding principles. So an investor declaration saying in specific terms that the investor has complied. Next slide. Now, what do we do with that? Arbitration is available under not just the exit rules, but also, interestingly, and we'll talk about this in the next section, under the Hague Rules on Business and Human Rights Arbitration, the Hague Rules with some amendments. Now, that's something that may take some folks by surprise. Aren't those rules that are specific to business and human rights arbitration? We'll talk about that in the next section. Deposits are paid by the investor. That's another way that the CIFCA builds in certain protections for the host state. Also, compensation and arbitral awards is dependent upon compliance with the UN guiding principles. So even if there is an award in the end of some amount of compensation that's due to the investor, then that amount must be decided in accordance with the compliance record of the investor. Next slide, please. Other key features. The tribunal shall exclude claims as inadmissible if the investor's declaration is untruthful, or if more than 5 years have passed since the claim arose or there was knowledge of the loss or damage. So the idea being here that there is the first gate. A declaration must be made in order for the host state to provide its consent to jurisdiction for the tribunal. And then the second gate for claims that if that declaration was untruthful in some respect, then the claims themselves are inadmissible against the host state. Next slide. Other key features, and this has been addressed here just a moment ago with some excellent comments that have been made by the last speaker, talking about consent and how investors can consent to specific terms and how that might look. In commencing arbitration under the CIFCA model, investors consent to recognizing human rights, environmental protection, sustainability, and investment protection as interrelated and arising directly from an investment. That last language, arising directly from an investment, of course, speaking to exit arbitration and jurisdiction under the Exit Convention. And generally speaking, this language is going to address one of the two major concerns that was cited just a moment ago as barriers that need to be overcome in order for treaties to contain investor obligations. Essentially recognizing that for a long time we have said, well, an investment is investment with some sort of expectation in our minds, even if the definition doesn't necessarily exist within the language of the treaty itself. Well, what an investment looks like when we see it. Maybe that's the idea. Here, investors consent specifically when they undertake investor state arbitration against this host state that has the CIFCA model in place, that they will recognize that it's not just the instant investment itself, but it's also the broader context, and specifically these facets of the context. Also, tribunal jurisdiction over any third-party claims asserted against the investor, and there's language included that specifically mentions class and mass claims as well. All of those are subject to the consent of the investor that are required by the host state in order to give its own consent to arbitration in the first place. Next slide, please. So broadly, and obviously this is an oversimplification as it's been illustrated by the excellent presentations that came before, but here's the simplification. Many people think that traditional IAAs primarily focus on investment protection. They primarily have key beneficiaries that are foreign investors, and that the risks may be disproportionately borne by host states. That's a common criticism, and it's behind much of the criticisms that have led to the current discussions of reform in the investor state context. Under the CIFCA framework, the purpose is to integrate both of those two regimes, investment protection on the one hand and business and human rights on the other, to reduce power imbalances and to promote sustainable development. Next slide. So now coming to the Hague Rules for just a moment before we move on. Next slide. If you're not familiar with the Hague Rules, they're based on the 2013 UNCITRAL arbitration rules, which are often used in investor state arbitration, including some of the key facets of the transparency rules. The stated purpose of the Hague Rules is to provide a set of rules for the arbitration of business and human rights disputes. So once again, why are we talking about this in the context of investor state arbitration? Next slide, please. The primary focus is on upholding responsibilities under the UN guiding principles. So once again, 1 and 3 for states, pillars 2 and 3 for businesses. But interestingly, we have also an unlimited scope. As with the UNCITRAL rules, the scope of the Hague Rules is not limited by the type of claimants or respondents or the subject matter of the dispute. Okay, and it also mentions state specifically. This is coming from the introductory note of the Hague Rules. So the Hague Rules were made, yes, with this particular purpose in mind, but also leaving the door open for its scope to be broader than that. And in fact, if you think about the purpose of the Hague Rules, where they're intended to address situations where there is anticipated to be a power imbalance between people who claim to have violations of their internationally recognized human rights on the one hand, and private sector industry with some resources on the other, you might expect that the sort of approach to developing the rules might be the sort of approach that many people would like to see developed in investor state arbitration today, where it's often the case that people say, well, there are maybe well-funded investors on one hand, and then on the other hand, you may have developing countries. Interestingly, that the Hague Rules have had this sort of thinking in place for the arbitration of business and human rights disputes, and that a lot of that also applies to our conversations today. So if we could, let's see, I think we skip back to the beginning. Looks like there were just a couple more slides toward the end. Oh. Are we able to, oh, hold on a second. So if we can scoot back just a little bit. A few slides, almost there, just a little more. Okay, and okay, if we can go back just a bit. Just a little bit more. Okay, good. So now, great. So you have this interesting situation where the Hague Rules have been targeted and intended for human rights disputes at the same time, business and human rights disputes, at the same time as some of those same concerns might be seen to be applicable in the conversations over reform of ISDS. Next slide, please. So features unique to the Hague Rules: inequality of arms, cultural appropriateness, and rights compatibility. Awards are required to be rights compatible. Next slide. Promotion of mediation, public interest considerations for transparency, expedited arbitration, and early dismissal. Just keep these words in mind just for a moment, realizing these are some of the features that have been put into the Hague Rules to address what has been seen to be an imbalance of power between parties. Next slide. So also features for controlling costs. And here it's possible to have a review of fees and expenses for the arbitration from the appointing authority, for example. Also, awards are supposed to be reasonable and account for cost burden on parties, departure from the loser pays principle. Next slide. Now, turning to future practice, and this is, I think, the important part and where we'll finish. Next slide. So, this interestingly may relate, like I said, to the ongoing conversation about possible reform of ISDS. Let's have a quick look at what was said back in 2017 when the working group was just getting underway they said some of the concerns, and obviously this is not to say these are the only concerns, but some of the concerns that they cited back in 2017 were lengthy duration and extensive cost of ISDS. These are concerns that might bring you to think that reform is a good idea. Lack of transparency in the proceedings, early dismissal mechanism, lack of a mechanism to address counterclaims by respondent states. Now, in the CIFCA, we have specifically addressed the extensive cost of ISDS to the extent that you've seen some of the mention of cost measures of deposits being required of investors up front, that the Hague rules also address this in the event that those are applicable as opposed to the exit rules. And also the lack of a mechanism to address counterclaims. We've spoken specifically to third-party claims even, and certainly within the treaty that can be built in as well. Why? Because once you have an investor-state arbitration, the tribunal has jurisdiction. Why does the tribunal have jurisdiction? Because of the consent of the parties. And as has been said here, at the stage of drafting a treaty, you may not have the consent of a third party that's not sitting at the table. But once that third party says, I accept the standing offer to arbitrate and starts arbitration, then the tribunal has jurisdiction because of that consent. And that consent contains the terms that were consented to, namely the terms of the treaty. If you see here the red, extensive cost, lack of transparency, lack of a mechanism, those are specifically addressed. I would also note that the lengthy duration and early dismissal mechanisms, those are also some of the things we noted just a moment ago in the context of the Hague rules, and how that if they are applicable, then those also might be addressed. It's interesting just to note that this might be something that could enter into this important discussion. Next slide. Okay, and so I'll leave you with this question, essentially this. Is innovative incorporation of investor obligations the future of ISDS? If the CIFCA can provide a more balanced investment treaty practice and increased public legitimacy of ISDS. Thank you.
Well, thank you very much to all of our panelists. That's been a really interesting tour de force through the different issues, beginning with the age-old problem that Clara took us through of investment treaties being asymmetrical and the obligations really being all on the states and not on the investors, and the investors having the rights. And Clara introduced us to the efforts in some treaty practice to put obligations on investors, which then leaves the problem of how those enforced. Jose Antonio took us through some interesting practice and some arbitration cases where counterclaims have been made by states, but there's a bit of a, I guess, a bit of a sorry record where counterclaims are made by states where those counterclaims are based on the bilateral investment treaty itself, maybe not so much where there's a contract also at issue where counterclaims have had more success, but in most of the treaty cases, the tribunals have even found, not even found on very many occasions, or only one occasion, the Urbasa case, that was even within jurisdiction. And Rob's taken us through some very, very recent, hot off the press work that's been done for a client state in developing a model investment treaty, not only to make it clearer what obligations are on investors, but also seeking to provide methods for host states, and not only host states, but also third parties to enforce those obligations, those human rights obligations on investors. We have about, I think, 10 minutes for some questions. So if anybody would like to drop a question into the chat box, I know there's been a very active chat box over the last sort of 20 minutes or so. I might begin by asking our panelists, and maybe it's a broad question. What sort of difficulties are there in some of the obligations? And we can begin with Clara, because some of the treaty standards provisions that you referred to simply referred to obligations on investors to comply with human rights. And what is a tribunal to understand what that refers to? Because human rights could be maybe the content of the Universal Declaration on Human Rights, or it could be the content of any number of a dozen or more international treaties. And is the tribunal to only be able to apply those human rights which reflect customary international law? Does it have to review the treaty practice of the relevant host state as to what human rights treaties it may have agreed to be bound by? How would tribunals address that particular issue? Maybe I can begin with you, Clara.
Yes, that's a hard. I mean, the example of the human rights is the most difficult one, because I suppose the standard view in international human rights law would be that there are no human rights obligations of business. And that was the problem that the UN guiding principles were trying to bridge by saying, okay, well, we are not going to go there, that we will introduce this idea of responsibilities. I already mentioned that. So I suppose some of the potentially human rights provisions, such as the references to the ILO declaration, that those may make it a bit easier because they provide a specific reference to more developed standards. If it's just a clause which says, businesses will uphold human rights, then obviously this opens up the question what that means. And I would, I guess I'm not offended by that language, given that this whole field has developed on treaty language such as, state party will provide fair and equitable treatment to the investor. I would expect that what the tribunal would do would in fact be to look at the relatively developed analysis within the business and human rights context. And I think here Robert and his firm were right to kind of try to merge these two, because the question would be, in what way do or can businesses, investors, I suppose, detrimentally impact the enjoyment of human rights?
Okay, thank you. Jose Antonio or Rob, would you like to chime in there?
Certainly. I concur with Clara that it would be very difficult to include language that would be too broad with respect to human rights, starting with the fact that the one primary subject that is given the responsibility to uphold human rights is the state within its own jurisdiction. So that's the way human rights are constructed. That being said, there may be some narrow language that would give that would make sense. For instance, the reference to fundamental human rights, or even the reference to a certain minimum or minimal international law standards related to the environment or labor, and this is a question that I have grappled with. If one could find basically those international minimal standards concerning labor, and there was a slide in my presentation which made a reference to ILO conventions, etc. It seems to me that in concerning labor, it might be a little bit clearer. Concerning environment, except for the precautionary principle, it may be more difficult, but I'm not an environmental law expert. It may be a little bit more difficult to conclude which obligations or principles may be customary. So I don't think that the obligations should be broad. They should be specific, and they should be related to this notion that investors should at least respect certain obligations that may already be there, that may already be customary. The problem with that, with not including those obligations in a treaty, is that they may very well exist in the public international law system. However, if you do not include them, the tribunal would not necessarily have jurisdiction over them. I mean, it depends on the tribunal, but I would say, well, it's not clear that that even though they exist, the tribunal would be able to rely upon those obligations to bring or to create some actionability before the tribunal. So that's sort of a question. That's why I believe that it's important to include them in a treaty. There are things that you don't need to include in a treaty, like general principles of law. the principle of good faith. Whether you include it or not, most tribunals have said, well, if you act in a corrupt manner, like in World Duty Free versus Kenya, or if you commit fraud, like in INSEISA versus El Salvador, you're breaching a general principle of law, which you do not necessarily have to have in a treaty. But for certain specific obligations, you may have to do that.
Thanks, Jose Antonio. I might just ask Rob a question, one of the questions which has come up in the chat, and that is whether there are any states that have yet signed and ratified a CIFCA type treaty, and secondly, is there any anything you know about what the impact would be on a state having a CIFCA type treaty, and the relationship or impact on foreign investment flows into that country? Do we know anything about those issues, Rob?
Sure. So this is, as you mentioned, hot off the presses. So this is a CIFCA model is what was developed for a specific context in very recent months. And it was just for the particular use of one state as a model bilateral investment treaty. It hasn't had the opportunity to be circulated yet. It hasn't had the opportunity to be considered regionally, but it very well may be. Because the idea is this here: if you accept, as a host state, if you accept the terms of a CIFCA treaty, what you're effectively saying is that it's not enough. The standard, traditional, old-fashioned bid from the 1990s or from before is not enough, because we want to not just have the inflow of investment, we also want to have protection. We want to have perhaps environmental protection. We want to have human rights protection. We want to have a responsibility, not just state responsibility under public international law. We want to also have some responsibility from the investor. And so if a host state puts that in place, you're essentially putting in, as the host state, first, a jurisdictional barrier that the investor must make a declaration first. After that declaration is made, that if that declaration was not true with respect to the solid human rights record you must have in order for the state to consent to investor-state arbitration at all, well, then you would have concerns with inadmissibility of the claims. And then moving on, the consent to third-party claims. Now, what would this mean for investors? Would investors be encouraged to invest? It depends on how you look at it. It depends on the context. You might think, well, gosh, that's a lot to take on for the investors. The investors only take that on, obviously, in the event that they specifically accept the standing offer under a bid to arbitrate. That's the only time that they'll offer consent to that. And so it's always just a facet. It's a feature of investor-state arbitration with a state that has a model bid of a CIFCA, style. And so with that being the case, I think also investors will see, look, especially if you're talking about developing countries have concerns that are not only related to inflow of investment. And they may very well see this as a positive step toward supporting increased rule of law and the establishment of higher standards. So it depends on how you look at it as an investor, and as a host state, there's not, by comparison to the standard bid model, there's a lot to be gained by having these additional protections from disputes.
Yeah, thank you. I might one question, taking several steps back from this topic, and that is that I suppose we began with the asymmetrical nature of bilateral investment treaties, that the obligations are on the states and the investors have the rights under this traditional model that we're used to, and that it may be possible for states to make counterclaims in certain circumstances. But I suppose there's and now there's maybe we should be putting in obligations on investors, and we've heard lots of good reasons for that. But on another view, is it not the case that obligations on investors as private entities, their obligations should come through domestic law, and all investment treaties either have an express or an implied requirement that the investor will comply with the law of the host state, at least in making the investment, and then if they don't comply with the law of the host state in the operation of their investment, that may affect the admissibility of the claim or the merits of the claim, or any award of compensation that might ultimately be made to them if they've carried on their investment in some kind of unlawful way, even if it was made in accordance with host state law at the beginning. And so I suppose my broader question here is this not really all a question of law enforcement and the content of the domestic law of the host state? And if the host state of the investment chooses to implement certain obligations concerning respect for human rights on companies that operate within its jurisdiction, that's a matter for the host state. And then there's going to be a requirement for any foreign investor coming into that state to do business there to comply with local law. And I suppose I'm being devil's advocate a little bit here, but the question is, why can't we leave all of this to the domestic law of the host state? Why do we have to try to overcomplicate a bilateral investment treaty by seeking to make them balanced in the sense of not only host states potentially able to make claims against investors, but even third parties? So can we not just leave things with as a matter of law enforcement within the host state? Maybe Clara, I'll go to you first, and then maybe to the others. It's a large question.
No, it's a very easy one. The reason is because where the money is. So the thing, this is not that discussed in the investment law community, but it's very much discussed in the business and human rights area, which is the money is with the parent company. So that's an entity which is outside of the control of the host state. So the host state may have some control over the local subsidiary, but will in principle not be able to reach the parent company. There have been some very recent cases in the UK and in the Netherlands where it has been possible for, but these were private claims. Those were not claims brought by states, where the victims were able to sort of bring a claim towards against the parent company. But the asymmetry is also at this level, right? So investment treaties will allow the investor, including the subsidiary and the parent company, to sue, typically the shareholder in our language in the investment area. But that is not the case the other way around.
Great, thank you. Jose Antonio and Rob, I'll maybe go to each of you for one sort of last comment before we have to, unfortunately, wrap up our panel, but maybe Jose Antonio, just in a minute or so.
Yes, definitely. My answer, I agree with Clara, but my answer is because it hasn't worked. That's really it. It hasn't worked, and there are still so many imbalances in the system, and we had a discussion in another panel as to the concerns of host states and developed host states, or developed exporting states to host states, that perhaps if the standards are increased in investment treaties, then we will affect investment. And the view sometimes of some businesses is not necessarily that they're afraid that the standards will increase, but they are afraid of uncertainty. To the extent that the standards are clear, even if they're higher, I think that their investment will keep on flowing, and I see it more as a discussion that is sometimes put on the table by council of investors. So you know, the frame of mind that thinks that, well, you already have the domestic law, so why don't you apply it? Is and I'm not saying that I'm not saying that about the question. I'm not saying that about your question, but I've heard the argument that it should be kept in domestic law by many counsel for investors that say, well, you already have the whole domestic law, but it hasn't worked. And what is wrong with creating international obligations that businesses will also have to comply with? And these are very basic obligations. We're not talking about covering the whole human rights, but these are very, very basic obligations about child labor, about gender equality in the workforce. These are very, very basic obligations that they should comply with, and sometimes they're not complying with. So if they if they were all to comply, I think that the system would be more balanced overall.
Thank you, Rob.
Thanks very much.
If you can manage in a minute.
I think I can. It's interesting to me to see, my esteemed co-panelist here saying things that are not academic, they're very practical. It's the money, right? Or it just hasn't worked, right? I think it's interesting for us to note that the whole question of why don't we just leave this to domestic law and enforcement kind of has that assumption that there will be that domestic law and enforcement uniformly around the world. If human rights are supposed to be universally applicable, well then bringing them even closer into universal applicability through incorporation in investor state dispute settlement context and in IAs probably makes some sense. It also probably promotes the rule of law more broadly, probably helps strapped states that yes, their heart is there in putting in the legislation or the regulation, but gosh, where are the resources? How are you going to have the resources necessary to make it an actuality on the ground? This just helps, that's all.
Great. Look, thank you very much, everybody. We've unfortunately run out of time for this panel session. I think the panelists and I are going to go into a breakout room to debrief, but for all of the participants, and we've had a very good number of participants at what is a very early hour. For those of you on the East Coast of the United States, if you're on the West Coast of the United States, it's very early. And for those of us in other parts of the world, it's getting kind of late as well. Can I thank Clara for an excellent opening presentation, and Jose Antonio and Rob for their remarks as well. It's been a very stimulating discussion and a conversation which I think is going to continue in the coming years as more and more people become engaged and more states become engaged with these issues, and possibly seeing a fresh way to look at incorporating investor obligations into bilateral investment treaties. So thank you very much, and I wish you all the best. Those of you who are continuing with other panels for the World Arbitration Update, there are 2 more panels today, as Ian Laird said at the outset. Thank you very much, everybody. Jose Antonio, Clara, and Rob, I look forward to seeing you in a breakout room in a second.
Thank you.
Thank you.